Well, I'm glad. Thank you, everyone who came back. You're here for what I think is an incredibly important topic, namely patent trolls, which for businesses today are becoming an increasing problem. I'm Matt Levy. I'm patent counsel with the Computer and Communications Industry Association. We're a trade group based in Washington, D.C. We have all sorts of members who are big and small computer and networking and communications companies. And right now, one of the issues that I'm working on is patent reform, namely dealing with patent trolls. So that's why I'm here. And I'm joined by Steve Vicinanza, who will be talking to you about his personal experience dealing with a patent troll, and John Harris, who's a local attorney who has dealt from the attorney side dealing with patent trolls. So let me ask, how many lawyers do we have left in the room? Oh, good, not too many. So I can be up on lawyers too. I am an attorney, but and so has anybody here actually been sued by a patent troll or dealt with it? All right. Well, if you haven't, you probably will be soon. So that's good news. So let's talk about what a patent troll actually is. They're ugly. And the basic thing about patent trolls, their whole business is making money using patents. They license them, they litigate them, they don't make a product, they don't sell a service, they use the patent system to make money. And they use the fact that it's, I won't say rigged, but it's heavily weighted towards the patent owner, which makes it very easy for someone to actually exploit this and make money with it. Usually, patent trolls buy their patents. It's not even things that they personally have invented, although sometimes it is. The basic thing is that a patent troll wants you to pay them money for something that you're already doing. So it's not that you stole somebody's invention or you took somebody's idea. It's something that you were already doing. Maybe in many cases you just bought a product at a store and then you get a letter telling you, oh, you have Wi-Fi in your cafe, or you're using a printer that scans and it sends documents by email, so you owe us money. It has become an increasing drag. In fact, patent trolls are responsible for an increasing amount of damage to the economy. In 2011, one study showed that there were about $29 billion, at least $29 billion in payouts. So these are companies paid to patent trolls. That's a lot of money. It's very profitable. But even more than that, it actually caused at least $80 billion in losses to the economy. And this is from legal fees, delayed hiring. Many companies get scared and don't move forward with plans that they had because they get nervous. And we'll talk about some of the effects. So again, because I work on the national level, I want you to get some idea of the trend that's going on before we focus on Georgia. So here, the red is the percentage of troll suits as a percentage of the total patent lawsuits that are going on. And you can see that that red area is growing. And in fact, it's gotten to the point now where most patent infringement suits are actually troll suits. And who are they going after? Well, it used to be that they went after high-tech companies because that's where, that you think of them as innovating. But there's been a disturbing trend, which is that they're now going after more and more non-tech companies. And you can see that in the most recent couple of years, most suits now are actually against non-tech companies. And if we break it down, you'll see that actually the biggest group that's getting hit is retail. The retailers are getting hammered. They're getting hammered because of products that they sell that, again, they didn't build, or computer systems that they use, or maybe things on their website. There's, again, more and more non-tech companies are getting hit. And the last thing I want to talk about, just on the effect, startups. So we are here, of course, talking about entrepreneurship. Professor Conley Chen just did a survey of startups and venture capitalists to look at the effect that patent trolls are having on them. Now, this was not a representative sample. These were people who responded, but just it was a pretty big sample. And just this is what they reported. So almost half had one or more significant impacts on their business. And you can see that, so the dark blue is the startup survey, the light blue is venture capitalists. And the venture capitalists had portfolios of startups, so they were more likely to be affected. Many of them had to change their product, they had to delay hiring, they had to delay some milestone that they were working towards. These are significant impacts. This is beyond just the money that they had to pay out. Many of them lost customers because what's happening is that many patent trolls are quite sophisticated, and if you're a startup, some trolls have decided to wait until you're in a particularly important position. Maybe you have a new round of funding, maybe you're in the middle of an acquisition, or maybe you've just gotten some big customers, and the trolls will pounce. They wait strategically until you really don't have much choice but to settle. So it's becoming, again, an increasing problem for startups. So we have with us Steve Vicinanza, who has dealt with one of these trolls, and so what we wanted to do is have him tell you about his personal experience, because it's a compelling story, and then I can fill in a little bit about what happened afterwards, and then John will take it from there. So Steve?
Okay, well, thanks. I'm CEO and founder of BlueWave Computing. We're an outsourced IT services company, which means we're a bunch of geeks with screwdrivers. We go around and make sure the computers work. We work with small business. We have hundreds of small businesses, mostly in Atlanta, where we manage their IT. And it might sound high tech, but it's not really. We don't produce any products. We don't make any technology. We just make the stuff work together and play nice. So we make the printer work with the network, with the computers. That's what we do. Before I get started, let me ask you something. How many people in the room have ever taken a document or a piece of paper, put it on a scanner, and pressed a button and scanned that to an email or a network? Could you raise your hand? Infringers! You stole my technology. I invented that. I invented scanning to a network, and you stole it. But I'm going to be a nice guy and let you off the hook. For $1,000 each one, I'll let you off the hook. Okay? Who's going to write me a check right now? What? You admitted you... Why would you write me a check for $1,000? Why won't you do that? You don't believe me? I've got a patent. Here it is. The U.S. Patent Office said, this is my technology. Now, do you believe me? No. Okay. So you're not going to write me a check for $1,000. How about this deal? I'm going to take you to court. And it's going to cost you maybe, I don't know, John, what is a typical patent suit, defending a patent suit? What can that cost you?
The average cost of defending a patent infringement lawsuit in the Northern District of Georgia exceeds $1.2 million.
$1.2 million, okay.
If you fight it, and that's a fight.
If you fight it, well, what's your choice? You can pay me or you can fight it. Is that
fight or you can pay?
$1 million or $1,000. Now who wants to write a check?
Okay, you can pay your lawyer. Remember, you pay your lawyer.
You have to, right, you pay the lawyer.
Got to pay the lawyer.
And maybe you win, and maybe you don't win, even if you're right. So the best you're going to do is maybe $1 million, and you might lose, and it'll cost you even more than that. And if you win, guess what? You can't get your legal fees back. Okay, that's how the patent system works in our country today. Okay? Well, that happened to me. I got a letter in the mail one day, and that letter said, "Dear Steve, it's come to our attention that you're scanning documents onto your network, and we own that technology. And we're going to be nice guys and let you pay us to license that technology for your business, and it's going to cost you $1,000 a person." And I said, "But this can't be real. I ripped it up and I threw it away, and I said, this got to be a scam." 3 weeks later, I get another letter, also from a law firm in Atlanta, saying our client, named Project Paperless, has decided that you've ignored us, and we're going to file suit against you in court. And here is a copy of the complaint that we're about to file, if you don't start talking to us about licensing our technology. Well, that kind of got my attention, okay? Because this was a real legal-looking thing. I mean, it had complainant and complaint, and said I stole their technology. What's the word they use? Stole. It said I stole their technology. And I said, well, we have 150 people times $1,000. That's $150,000 for a $200 scanner that we have on our network. And I scratched my head. I called my attorney. I said, yeah, you better deal with these guys. So I got really mad. I'm a computer guy going way back. I've been 30 years in the industry. I've got a doctorate in information systems, and I know a little bit about technology. So I looked up their patent, and I tried to make sense out of it. And I'm a pretty technical guy. And I couldn't make any sense out of it. And certainly not how they got from what was essentially a little piece of software that they patented like 10 years ago to, therefore, anybody that scans a document to an email system is infringing. That was their claim. And the whole thing didn't make any sense. So I said, you know what? I don't know if I can take this. It turns out that this company called Project Paperless was actually owned through a series of shell companies by the law firm itself. So their client was really themselves. Isn't that interesting? So I tracked it down. It was a condo in Arlington, Virginia. That was their headquarters, world headquarters of Project Paperless, a condo. And I said, wow, this makes no sense at all. Well, I did a little more research, and I said, you know what, there's actually prior art out there from the copier companies, Canon, Ricoh. They actually had patents that predated the patent that Project Paperless claimed. But of course wasn't referenced in their patent, so I had prior art. I had this is a classical patent troll. Now I had never heard of patent trolls. I didn't know what a patent troll was, and I think my life would be a lot happier if I never did. But we decided that we weren't going to sit back and take it, because they were not only suing us. In their complaint, they listed 100 John Does. And those John Does were our clients. They said, you know what, you're going out and you're screwing these things in and you're putting IP addresses in these printers and scanners, and so you're contributing to their infringement. So it's not only you, but it's all your customers, and we want your customer list, because we want to go after them too. So it wasn't just us. So I said, I'm not going to take this. So what we ended up doing was filing a counterclaim. When we had to answer to them, we said, number one, we have prior art. And we sent them the prior art. And they thought it was pretty good. And number two, we brought in all the copier companies. So I said, you know what? Xerox, Canon, Ricoh, Kyocera, Brother, Panasonic. We listed them all in our answer and said, these are third-party defendants. We want you guys to defend us, because it's your copier. And here it is on page 17 in your manual, how to scan to email. Okay, well, it's your fault. So we brought them in. And I guess we were one of the lucky ones, because it cost us about $50,000 in legal fees and patent searches and everything else. But they turned their tail and run. They didn't want that. They didn't want to have that fight. So we won. Essentially, winning cost us $50,000, and we were one of the lucky ones. Okay, we got off easy because they really weren't ready to have that particular fight. They ended up going away, and I think we'll find out what happened to Project Paperless after that.
Well, so thanks, Steve.
That's my story.
Yeah, so it's a great story, and there are a couple of things in the story that you should notice that patent trolls often do. The threats, of course, are pretty commonplace, threats without very specific demands. And notice who they went after, right? They went after Steve, who just used the product. They did not go after Canon or Ricoh or Xerox. Why not? Well, because one, they would fight and very well might win. And also, if they actually negotiated a license with those companies, then that would apply to all their customers, and that would dry up their pool of funding. So this is a really common tactic. Now, what happened to Project Paperless? They're still here, but they morphed. So what they did was they transferred the patents to another entity called MPHJ Technology, a wonderful name, owned by the same people, by the way. So it's same exact people. Then this company formed yet another layer of these really strangely named things, Ads Pro, Gosnell, just really nonsense names. And those companies sent out demand letters Same demand, $1,000 a user, pay up, and they started going after really small businesses. Just mom and pop shops, small organizations, even nonprofits in some cases. So they've just gotten incredibly aggressive in Georgia, in a bunch of states, including Vermont and Minnesota and Nebraska, which brings me to what's happened this year, is that some states actually fed up with the whole thing, have started taking some action. So a few states actually did something about it. Vermont was the first one. Earlier this year, they passed an anti-troll demand letter law, basically, and then the AG sued MPHJ. And that's still pending in court. Nebraska actually went after the law firm, sued them, and that's still pending. That's being battled out. And Minnesota actually is the most interesting one. Somehow, the AG managed to, I don't know what she had on them, but she managed to negotiate with them and get them to stay out of Minnesota altogether. I have no idea what she did, but good for her. But, so next, John's going to come up. As he can tell you, they're still around, although they may have, we'll see what they're up to now, and he's also had some experience with other trolls that he can talk about. So let me hand it over to John.
Thank you, Matt. I'm John Harris. I'm a partner with a law firm here in Atlanta, Morris, Manning & Martin, and we have a technology practice, and I've been a practicing patent attorney for 33 some odd years. I spend most of my time helping clients acquire patents. From time to time, I will have a client that will acquire some patents that might get bought by some entities that either might use them for purposes such as we've described here. Did you know that companies, the patent troll phenomenon, that's not the term we used to use for them back in the 90s. We used to call them patent pirates. But they've been around in various forms and fashions for years.
Actually, in the 19th century, they were called patent sharks.
They were called sharks, then they were called pirates. There is one particular company in the 1990s called Jerome Lemelson, who funded a chair at MIT called the Lemelson, and has the Lemelson Foundation. If you listen to National Public Radio, from time to time you'll hear sponsorships coming from the Lemelson Foundation. Well, Lemelson was an inventor who was one of the most notorious alleged patent shark / trolls. He's made over $1 billion from enforcing patents that he either came up with himself or he acquired from other people. There was a gentleman named Ron Katz, based out of Beverly Hills, who came up with a series of patents relating to managing call centers and software for call centers. He also began to enforce patents against a number of companies that ran call centers or delivered software for call centers. He also has made over $1 billion for himself and his related companies. He actually was also related to American Express, and there's a strong tie between Ryan Katz and American Express, so you can look at some respects and say, well, there has been some financial benefit to come out of some of these kinds of activities. In Georgia, back also in the 90s, there was a company called AudioFax that would go around and sue on patents that originated here in Georgia relating to fax broadcasting. Of course, fax broadcasting is something that's gone away, but for a number of years, that was a very important business. That company made a lot of money and was run out of here in Georgia. There's another outfit that's now making the rounds called Arrival Star. You'll hear that name if you are in the business of trying to track products being shipped in interstate commerce, such as by FedEx or UPS, and having some kind of a notification delivered to you or your handset or your computer to alert you of the imminent arrival of your product. Arrival Star had its genesis here in Rome, Georgia. And so the people that are behind that particular family of patents, there's roughly about 13 of them, are making the rounds these days. So there's some benefit to the local economy that has come to some degree by people who are in the business of aggregating patents and perhaps not even practicing them themselves. What seems to be the most objectionable part of the patent troll term is the behavior of the people that own these patents and the way that they go about targeting lawsuits and making demands for $1,000 per person. It just doesn't feel right to be a small business person and then, unbeknownst to you, as Matt said before, you've been doing what you've been doing. You've been scanning documents to email, or you've been scanning documents to storage because you bought a scanner from Canon or Ricoh, and out of the woodwork pops someone demanding that you pay them $1,000 per person, and you're stuck with the notion of, am I going to fight this? And thank goodness for people like Steve here, who decided he was going to invest his own funds and become sufficiently righteously indignant at this behavior that he was going to stand up to them. But if you're a 3 or 4 person accounting firm and you get one of these demands and you're looking at the prospects of $50,000 or more to stand up to one of these demands relative to trying to settle for a few $1,000s, is a difficult financial decision and puts a burden as you try to decide, am I going to fight or am I going to pay? So,
yeah, as I often say, once you've been sued by a patent troll, you've already lost. You're going to pay out a lot of money. The only question, pay it to, and how much. You're going to pay it to your lawyer, to the troll, or both.
So to kind of wrap up one particular point about the so-called scanner troll, that one of the companies that I ran across with for a client is one of those strange name companies called CalLad, C-A-L-L-A-D. We have no idea what those letters stand for. And you start working your way back through the ownership hierarchy, it's very difficult to find out who's doing what. But a series of actions have been taken by Hewlett-Packard, Xerox, and Ricoh, the manufacturers of these machines. They've pretty well stepped up to the bar and have now begun to take action to defend not only themselves from selling their particular products, but also to stand in front of their customers. And that's one of the important things about how to handle a situation when you're buying a product from someone else, that the result of your use of that product is you need to make sure that your agreements to purchase these products have patent indemnity provisions in them. If you don't, and sometimes you're not going to get those, but you want to be careful to get protection from the people you buy equipment from.
Right, and even with an indemnity provision, you're still going to end up losing time and losing a lot of resources. So we painted a pretty dreary picture here. It sure seems like you're stuck. And to some extent, unfortunately, that's true. But I'm happy to say that there actually is some help, hopefully, on the way. That in Congress, surprisingly, there has been a ton of attention on this issue, bipartisan, actually. So I'm going to give you a very, very quick overview of what's going on, because we don't have a lot of time, and I want to make sure we've got time for questions. There are currently 6 bills that are pending. There are a couple in the Senate. There are 4 in the House. They're dealing with, one, the litigation side to help try and reduce some of these costs so that maybe you're not going to be out $1.2 million, maybe you'll be out less, but still some, unfortunately. So these are a number of bills that have been proposed. I don't have time to get into them. The other aspect is to deal with the patents themselves. You've heard us talk about these patents. They may sound ridiculous to you because they are ridiculous, but because of the nature of the patent system, it's really hard to get rid of them. So there are a couple of bills that have been introduced, one in the Senate, and then a similar bill was introduced later in the House, the STOP Act, to help deal with this. The STOP Act actually is extremely important. Our organization supported all of these bills in some form or another. The STOP Act, we think, is critical. Actually, we have a bunch of letters outside on the desk to representatives of Georgia. If you are interested in this issue, we encourage you to take a letter for your representative. In particular, anyone in Hank Johnson's district. Representative Johnson is on the Judiciary Committee, which deals with this. He's on the right subcommittee, too. So, although he's been somewhat supportive, we'd like to, give him that push, so maybe he'll co-sponsor it. But if you want more information, one more thing, the chairman of both committees are also working on drafts, which we'll see. If you want more information, go to patentprogress.org. We have a guide to the currently pending legislation, and we'll keep it updated so that you can find out what's going on. So, we have a couple minutes at least for questions, and I don't care about your schedule, so we can run long if people have questions. So please take, you there, and make sure that you have the mic before you start your question. All right, but don't let that gentleman afterwards.
Excuse me, Trip Martin with Georgia Link Public Affairs. Do you have some model legislation we could consider or look at for just the state out of your association?
Our association actually works on the federal level, but I would encourage you to take a look at what Vermont did. So Vermont, again, passed a bill to deal with these demand letters. And if you want to see me afterwards, I'm happy to get you a pointer to that. There's a question over there.
Hi, I've been on both sides of this, both trying to protect some ideas and also having been sued twice. And it seems like, and both of them were bogus patents that our attorneys said, this will never stand up if it goes to court. However, what they're not going to let it go to court. They're going to let you spend so much money, so much money, so much money, and then finally drop it right before it goes to court. Seems like to me that there's two other things that need to be done. One is that if you, and I'm going to liken this to war because that's what you're doing, you're going to war. Hitler was not able to say, and you can see what I think of these folks, Hitler was not able to say, you're approaching our German borders, we're stopping the war, we're calling it off. You know, once he started that war, we were going all the way. And so that's the thing there that I think that if somebody starts a suit, you know, the defendant needs to be able to say, wait a second here, we're continuing on to go the whole way. The other thing is that I think you need to be able to sue the main defendant, because what we had was a case where they sued a customer of ours up in New York State and tried to force us to defend up in New York State. So those are two things that I think would make a tremendous difference in terms of leveling the field.
Well, so let me deal with your second point first. That end user protection that you're talking about is in the it's the Patent Innovation and Litigation Act, which was introduced by Farenthold and Jeffries in the House. There's one provision that would basically, assuming the company wants to come in, they'd be allowed to come in and take over the suit, and the customer would just be able to sit it out without spending any more money. And sorry, your first point had to do with Hitler and fighting it out. So there's actually a paper that came out a little while ago. It turns out that the best strategy for a patent troll is early on, the first couple suits, fight them as hard as you possibly can. Show that you're not going to quit. Because everyone after that you approach will see that that you weren't going to quit, and so they become worried that they're not going to be able to get you to go away. And they start looking at the bills. If you have the money to fight it out, God bless you, and you'll be doing a service if you can get rid of them. But you know, unfortunately, the reality is not everyone has the army to fight with, and you've got a business to run, and you don't necessarily want to tie everybody up and tie up your capital. So it's a really tough position to be in. I don't blame anybody who settles. It's a very tough choice. Any more questions? Wow. Well, so seeing none, thank you so much. I want to thank Steve Vicinanza and John Harris for being on our panel. I enjoyed listening to them. I hope you did.